So, as to regarding judicial review or constitutional remedies as available under Article 32, already we have discussed 10 different selected heads that we have made while explaining the very interpretation and pronouncement of the apex code. And now we'll go to the third read, that is certiorari. And regarding certiorari, we'll discuss the first important leading case, that is Himmat Lal versus State of Madhya Pradesh, which was decided in 1954 by the Supreme Court, where it was the observation that certiorari may be issued where the law under which the decision was given is void. And now we'll go to the second important leading case relating to the writ of certiorari is Ranjit Singh versus Union Territory of Chandigarh. In 1991, the Supreme Court expressed that the decision itself, if itself violates fundamental rights, or the decision violates the law or is without jurisdiction, then the writ of certiorari could be issued. And now we'll go to another important leading case, and that is Delhi Transport Corporation versus Mazdoor Congress. In 1991, Supreme Court expressed that the decision, if it is against natural justice, malefied, perverse, or based on non-applicability of avenue, so decisions violating fundamental rights as provided under category B above, and as the decision itself violates a fundamental right, as illustrated by situations where fundamental rights violated are those created under Article 14, then there would be likelihood of issuance of the writ of certiorari as it was observed by the apex court in Delhi Transport Corporation versus Mazdoor Congress in 1991. And now we'll go to another important leading case, and that is Union of India versus DIP. In 1993, Supreme Court made the observation that wherever any decision is against natural justice, or malefied, or perverse, or based on non-applicability of the avenue available to such court, then the apex court could issue the writ of certiorari. And now we'll go to the next writ, and that is quo warranto. And as regarding quo warranto, we would like to discuss only one important leading case, and that is Rajesh Abasti versus Nandlal Jaiswal, which was decided in 2013 by our Supreme Court, where it was clearly issued the very writ of quo warranto, also the very locus standi of the issuance of the writ of quo warranto. And in that context, the apex court pronounced that a citizen can claim a writ of quo warranto, and he stands in a position of relator. He need not have any special interest or personal interest. The real test is to see whether the person holding the office is authorized, authorized to hold the same as per law, as it was pronounced by the apex court in this important leading case, Rajesh Avasti versus Nandlal Jaiswal in 2013. And now we'll go to discuss about writ jurisdiction, and in relation to that we'll discuss certain important leading cases in regards to the very writ of writ jurisdiction as provided under Article 32 and how it was interpreted, widened, and expanded by our apex court, and in relation to that we'll discuss the first leading case, and that is Kongnima Lepcha versus State of Sikkim in 2010. The Supreme Court expressed that the directions for investigation cannot be given by Supreme Court in exercise of writ jurisdiction where statutory remedies are available. And in that particular leading case, it is wisely interpreted by the apex court that if statutory remedies are available, then there is no need of any direction for investigation. So, this is how it is interpreted, and now we will go to another important leading case relating to writ jurisdiction. Arun Kumar Agrawal versus Union of India in 2013, Supreme Court expressed that the Supreme Court sitting in the writ jurisdiction under Article 32 of the Constitution cannot sit in judgment over the commercial or business decision taken by parties to the agreement, which has been duly taken after evaluating and assessing its monetary and financial implications, unless the decision is in clear violation of any statutory provisions or purpose, or is taken for improper motives, then there would be no need of issuance for any writ, as it was pronounced in this leading case, Arun Kumar Agrawal versus Union of India, regarding the very issue of any writ by the Supreme Court. And now we'll go to another important leading case, and that is relating to this government of Meghalaya versus High Court of Meghalaya, and it was decided in 2016. And as here it was expressed that the constitutional courts have power to entertain letter petitions and has also power to deal with letters as writ petitions, and there cannot be uncontrolled exercise of the epistolary jurisdiction of the Supreme Court, as it was pronounced by the apex court in this particular leading case. And now we'll go to another important leading case relating to writ jurisdiction, and that is Amar Singh versus Union of India. And in this particular leading case, Amar Singh versus Union of India in 2011, Supreme Court expressed that whenever there is any writ petition, if it is frivolous and speculative, and the very question of tapping the telephone cannot be gone into on the basics of the petition with a weak foundation, where a writ petition is frivolous and is speculative in character, and in such case the writ petition could not be admittable as it was observed by the apex court. And now we'll go to another important leading case, and that is relating to another important leading case, and that is Census Commissioner versus R. Krishnamurti. And in regards to that, we'll discuss the very observation made in this regard. Census Commissioner versus R. Krishnamurti in 2015, the Supreme Court observed that there must be a clear breach of fundamental right not involving disputed questions of fact in regards to issuance of a writ petition. And now we'll go to another important aspects, and that is relating to the limits of writ jurisdiction. And in that connection, one important leading case is Northern Corporation versus Union of India. In 1990, Supreme Court made the observation that policy preferences not involving fundamental rights cannot be agitated under Article 32. Articles of the Constitution cannot be meant to indicate policy preference. So also we could discuss another important leading case, and that is relating to Hindi Hit Rakshak Samiti versus Union of India. In 1990, Supreme Court expressed that government policy cannot be enforced by writ under Article 32. And now we'll go to another important leading case regarding the very limits of writ jurisdiction under Article 32, that is Food Corporation of India Workers Union versus Food Corporation of India. In 1990, the Supreme Court made the observation that a question that can be agitated under the Industrial Dispute Act 1947 will not be normally allowed to be agitated under Article 32. So it is otherwise we could say if there is any alternative remedies, then it would not be wise to go for Article 32, which provides only writ jurisdiction, as it was observed by the apex court in this particular leading case, Food Corporation of India versus Food Corporation of India Workers Union versus Food Corporation of India. And now we'll go to another important leading case, and that is relating to Suresh Seth versus Commissioner Indore Municipal Corporation, and it was a case of 2006 where the Supreme Court made the observation that court cannot direct legislature to make particular enactment as it was declared in this particular important leading case regarding the very limits of writ jurisdiction as interpreted by the Supreme Court. And now in that context we could like to discuss another important leading case, and that is B. Krishna Bhatt versus Union of India, and which was decided in 1990 by our Supreme Court, and that is relating to the very limits of writ jurisdiction as provided under Article 32 and as it was interpreted by the Supreme Court. So, in regarding to that, it was object that under the Constitution and as under Article 32, so in this particular case, it was pronounced that the very limit of a writ petition to be filed before the Supreme Court in relation to any grievance which relates to certain legislative enactment, then in such cases the court has limited power to give any direction to such legislative authorities or to the legislature. And now we'll go to the 14th or the last one that we have made, and the very heading that we have made is regarding legislative enactment and writ jurisdiction. And in that connection, we'll discuss the very important leading case, Binay Vishwam versus Union of India. So, in that particular leading case, the very legislative enactment and as relating to writ jurisdiction was interpreted by our apex court, and that is exactly as pronounced by our Supreme Court is that the very provision relating to legislative enactment as relating to writ jurisdiction, as we found that the very provision relates to the very limitation or limited power in the hand of judiciary in issuing writs against any legislative enactment, and as such we have to discuss the very provision relating to this power. So in that connection, the very limitation to this power of issuance of writ, that as it was observed by the Supreme Court, that the very limitation as to the power of writ petition, as exactly it is mentioned, that the Supreme Court has limited jurisdiction in relation to giving any direction to legislative authorities. So, hereby we would like to complete Article 32, which provides constitutional remedies or judicial review. And as almost we have discussed 14 different heads, so also the number of cases that respectively associated with this separate provisions as falling under Article 22. So, in our upcoming video, we would like to discuss the directive principle of state policy as it falls under Part 4th of the Constitution, and this directive principle of state policies under Part 3 will start discussing from Article 36, and as we know, these directives given to states such as these rights are not fundamental rights, so these are not enforceable, neither justiciable. So in our upcoming video, we would like to discuss about the direct principle of state policy, which are neither enforceable nor justiciable in court of law.